Hello, this is Michael Brown with Avalon Risk Management, your premier provider of insurance and surety solutions for the transportation industry. In our last episode, we covered the new financial responsibility requirements for transportation brokers and domestic surface freight forwarders. We have discussed the definition of a transportation broker, as well as their arranger or travel agent for domestic freight status in some detail in earlier episodes. Today, I would like to talk about domestic surface freight forwarders and how they differ from brokers. It's important to understand the differences if you plan to apply to the FMCSA for authority and are uncertain as to whether you should become a broker or forwarder. Domestic surface freight forwarder is defined as a person or entity that holds itself out to the general public as providing transportation of property for compensation, and in the ordinary course of business, assembles and consolidates or provides for assembling and consolidating shipments and performs or provides for break, bulk, and distribution operations of shipments, assumes responsibility for the transportation from the place of receipt to the place of destination, and uses for any part of the transportation a rail, motor, or water carrier subject to the jurisdiction of either FMCSA or the Surface Transportation Board. In spite of the government's definition of a forwarder, in the real world, forwarders often arrange for shipments that they do not physically handle. Many of these will also be full truckload shipments that do not require consolidation. For those familiar with ocean transportation, you will note that this is not unlike an NVOCC handling full container load shipments, something that runs contrary to the moniker Ocean Consolidator. In fact, there are many parallels between the worlds of ocean and domestic surface transportation. NVOCCs and domestic surface freight forwarders both assume liability for the freight they move, and both also issue bills of lading showing themselves as carrier. Ocean forwarders and transportation brokers, on the other hand, are arrangers or travel agents for freight. They do not, by statute and regulation, assume liability for loss or damage and do not issue a bill of lading in their own name. Just remember that forwarders play an opposite role in the two environments. A domestic surface freight forwarder is a principal, while an ocean forwarder is an agent. Probably the most important concept to remember about domestic surface freight forwarding is the fact that forwarders assume CARMAC liability for the shipments that they arrange. CARMAC is the same liability regime that applies to motor carriers. CARMAC imposes strict liability on motor carriers and forwarders. This is much more favorable to the shipper than a negligence-based regime like the Carriage of Goods by Sea Act that applies to NVOCCs and ocean carriers when moving ocean cargo to or from the United States. Under CARMAC, a forwarder is by default liable for the full value of the shipment. The Federal Released Value Doctrine allows forwarders to limit their liability to an amount less than full value. In order to do so, a forwarder must provide reasonable notice of their limited liability and offer a fair opportunity to purchase higher liability. Exactly when and how this communication occurs and how it is acknowledged is of vital importance. Forwarders generally utilize some combination of bills of lading, rules tariffs, and contracts to accomplish this. If done incorrectly, however, a shipper may breach a forwarder's limit of liability, which would result in them being liable for the full value of the cargo. For this reason, forwarders should consult with a qualified transportation attorney when developing documentation and procedures. Finally, it is important to note that the way in which forwarders must handle claims is very different than it is for those involved in other modes of transportation like ocean or air freight. This is because of the very broad nature of the liability regime. CARMAC also imposes an entirely different set of standards and time constraints. There are, for instance, generally 2 time bars that forwarders utilize under CARMAC. The claims must be lodged within 9 months, and that a civil action must be instituted within 2 years of a denial of part or all of the claim by a forwarder. If a forwarder either fails to deny an uncovered claim or does so improperly, liability can remain into the future. There are cases of suits being brought years after a shipment actually moved. These are often difficult to defend as documents will often have been destroyed. It is important for forwarders to have the proper insurance coverage. Avalon's Combined Transit Liability Program is specifically designed for third-party logistics providers. We have a fully staffed transportation claims department and also offer educational training for our clients. Today we discuss domestic surface freight forwarders. If you have determined that you engage in activities that require you to have authority from the FMCSA as either a broker or forwarder, you now hopefully have enough information to decide which authority is right for you. In our next episode, we will talk about the process of applying to the FMCSA for authority. Thanks for watching.